those, of course, in state government and their agents in the various towns and counties. Tracy Arnold lives in Adamsville in McNairy County, and she has a story telling about her arrest on May 29 of last year. That's May 29 of last year. Tracy, are you there?
Yes, I am.
Hi. Well, listen, my listener and I would like to hear what happened to you. First of all, what happened to you on May 29 in the town of Crump, Tennessee? A story that should draw a great deal of interest regarding our rights of free movement on the people's roads.
All right. Well, I had my 6 daughters and my 2 nieces. We were headed to the park, and it was Memorial Day, which I should have known that I shouldn't have been on the roads without a license plate, without a license, without insurance on that day. But I wanted to take them to the park. So I took them to the park. Well, I was headed to the park, and sorry. Hold on. So we were headed to the park, and I got stopped, and the officer kept us on the side of the road for over an hour, and I didn't have a license plate, didn't have a license, didn't have a tag, and he was asking why, and I was like, I know of no duty to pay a privilege tax because a privilege is for-profit activity affecting a public interest. And I asked for a supervisor, I asked for his lawyer, and I asked for the mayor, and he denied. He said he was the supervisor, which he wasn't, but he wouldn't call for any backup, and he took me to jail. And I got to jail, and he was laughing about, he's going to charge me with false identification. And I said, I'm sorry, you're going to do what? And he was like, oh, that's none of your business. But false identification is you receive some type of goods, privilege, or service using false information, I guess. And but anyway, so that was that day. And after I got out of jail, I tried to go pick up my car, and I was told that I couldn't pick it up. So we waited until I went to court on June 13th. Actually, I had arraignment that Friday. So I went to arraignment, and the judge was trying to push me to trial at the next proceeding. And I was like, I told him that I moved the court for a preliminary hearing, and that's a probable cause determination because I requested the officer to take me before a magistrate immediately, but he just laughed at me and put me in a cell. So anyway, so I get to the probable cause hearing, and the officer's not there. And so the state's prosecutor says that the state doesn't wish to prosecute, and the officer's not here, so they dismissed all charges cost to the state. So I took that judgment to the tow company that's contracted with the city and said, all charges were dismissed. And he said, well, I still can't give it to you. You're going to have to get permission from the officer. So they totally left it to the officer to provide, I guess, due process, or, they treated the officer as the judge. And I was like, where I need all paperwork in regard to the taking of my property. And he said he doesn't have anything. And I've done FOIA requests since then, and they are relying on no law. The only laws that they have are these tickets that were dismissed. There's no tow-in form. There's no seizure form. There's no forfeiture hearing. There was absolutely no hearing and no documentation in regard to the taking of the property. And I've just been studying. My deadline is May 29th, obviously. So I'm just studying, and I got a suit drafted, but I just want it perfected, and I don't want to have to submit and amend.
This is David Toulis. We do thank you for joining us. We're talking with Tracy Arnold. She's 25 years old, a young mom. She and her husband, Bill, have 6 children. And she was charged for being on the public road without a driver's license. The charge was driving. Let me ask you about the charge, Tracy Arnold. How is it that the charge driving is not that is not a fact? That is actually a term that denotes a conclusion of law as to what the person behind the wheel is doing. Were you driving or traveling in your van on that morning of May 29?
Well, I would say that I'm certainly traveling because driving statutorily is defined as one operating a motor vehicle. And the courts have ruled that a motor vehicle is comprehensively defined and that it requires the payment of a privilege tax, which is for-profit activity affecting the public interest. All that goes back to privilege. I mean, you can look at cases and it says that operating a motor vehicle is a revocable privilege. And I mean, we have Tennessee cases that even say that the essential elements of the definition of privilege is occupation and business and not the ownership simply of property or its possession or keeping it. The tax is on the occupation, business, pursuits, vocation, calling, and it being one in which a profit is supposed to be derived from its exercise. From the general public, it has to be for-profit activity affecting a public interest. And that's what a motor vehicle is. It is an instrumentality of commerce.
And so when you were there with your 6 daughters and your 2 nieces that morning in May of last year, you were not affecting the public interest by using that van that has an engine in it, a gasoline run engine, has wheels, it has a body, it has brakes and all the equipment. You weren't using that machine in a public way, in a way that affected the public interest. You're suggesting, Tracy Arnold.
I was not using it for profit. I do not use the roads as my place of business, and I only use the roads in the usual and ordinary conveyance of the day, which the Supreme Court has said we have an absolute right to the use of the roads in the usual and ordinary conveyance of the day, and that the use of a motor vehicle is a special and extraordinary use of the roads.
In what way does the court say that a motor vehicle is an extraordinary use of the road? In other words, different from an ordinary use, Tracy?
Let's see. Here we go. It is, it's actually, let's see, I think it's 287 U.S. 251. First, it is well-established law that the highways of the state are public property, that their primary and preferred use is for private purposes, and that their use for purposes of gain is special and extraordinary, which generally the legislator may prohibit or condition as it seems fit. And if we have an absolute right to the roads, you cannot condition a right. Now, it is true that a privilege is a special right, but it is also for-profit activity affecting a public interest, and that comes from Corpus Juris Secundum. And cases, I mean, it's clear what a privilege is.
And so what you're suggesting, Tracy Arnold,
they don't teach you that in public.
No, Tracy Arnold is a homeschool mom, and her young charges are not in the public factory school. We're talking with Tracy Arnold. Now, how is it that the town of Crump and the towing service, which has contracted to serve the municipal corporation, is holding your van? And you mentioned that you're preparing litigation to be filed soon to avoid the loss of that right to sue under the statute of limitations, the federal statute of limitations for that offense. What will you be saying, and what are the grounds of your claim to get your van back, Tracy Arnold?
Well, first off, they acted under color of law because by law they were required to attach a token form to the property. By law, they are required to hold a hearing to find out whether or not the taking was lawful or not. So that they, and, oh, I'm getting lost here. I don't have my suit in front of me, and I haven't worked on it in a few months, but, they're just required to provide due process. And I wasn't using the roads as my place of business, and there's no legal duty to pay a privileged license tax. There's no breached legal duty. I mean, I have no idea. All they can throw at me are these penalty provisions. If you don't have a license, you can't use the roads. Well, it sounds to me like you are resurrecting the Dred Scott decision, and all the people have to wear their badge in incidents of slavery. Either that, or there is for-profit activity affecting a public interest.
And you're mentioning Dred Scott. Go ahead.
Oh, I was just going to go ahead. I'm sorry.
Well, the Dred Scott decision, if my listener doesn't remember, is the decision by Roger Taney just before the outbreak of the war, which secured slavery as an institution in American life. And one of the most remarkable paragraphs is the exclamation by the judge that we can't possibly have manumission of slaves. We can't have them to be freed. There are many reasons he gives, but one of them is that black people would be on the road without permission. They would be on the road without permit or license, and that, in his mind, was simply intolerable. And so that's what Tracy Arnold is mentioning. And that by the way, is that provision, that paragraph is cited in the David Toulis Transportation Administrative Notice. Now Tracy Arnold, Neil Pinkston in the Chattanooga area is the district attorney, and he has a letter to me in which he says there is no constitutional right to travel. There is a constitutional right to freedom of movement between states. And here he just repeats what the Tennessee High Court suggests in its policy, and that is that it continually rejects the arguments of the right of travel. Though it admits the right of homosexual marriage, it admits the right of killing your child by abortion. The idea of movement, private movement on the public's roads, it says is untenable and cannot be suffered. It has to be, all travel has to be subsumed and absorbed by transportation. So what is the difference between transportation and travel, Tracy Arnold?
Well, travel is the free movement. You're exercising your right to liberty. You're leaving. You're not, placed under a civil death sentence. You're not told that you can't go to the doctor without this badge. Transportation. I can't exactly articulate transportation because I'm familiar with the term commerce, interstate and intrastate commerce. Now, in other states, they call it transportation, but I would like to actually read a few cases on your rights. And is that okay?
Go ahead.
All right. At 405 U.S. 330, the right to travel is an unconditional personal right, a right whose exercise may not be conditioned. That's interesting. And let's see, 380 U.S. 528. It has long been established that a state may not impose a penalty upon those who exercise a right guaranteed by the Constitution. Constitutional rights would be of little value if they could indirectly be denied. Now, we have the right to freely associate with our family. If we have to have a badge, an incident of slavery, or a license, to leave our house, and well, they can't prove that we actually have to have that. They just say we have to have that, and our parents say we have to have that. But regardless, you don't get to freely associate with anybody without permission. You don't get to go to the store. Anyways, another one is 357 U.S. 116. The right to travel is a part of the liberty of which the citizen cannot be deprived without due process of law under the Fifth Amendment. Where did we get notice that we were required to have a license? Where did we get we're just told that we have to have it. How about you take us to court or give us some type of notice with some type of, just the officers and just people telling you have to? That's not due process. I want to know why. I want to know the duty.
You want to have you want to be notified as to what the duty is, and has your case was dismissed. Did anybody did the officer who arrested you say you have a duty to have a license? Did he say that, since he seemed to be the judge as well as the arresting officer?
No, and nobody can answer the duty to pay a privilege license tax. In Tennessee, the registration constitutes a privilege tax. And then another statute, I think it's 58102, which that might be registration, or I don't have them in front of me, but it actually defines a privilege tax as a tax on the business, occupation, vocation, or the like. So it's a privilege tax. If the registration constitutes a privilege tax, then that's a tax on business, occupation, etc. And, I'm asking them to prove me wrong. That's all I want. That's all I'm asking. That's all this fight is about. Tell me I'm wrong and prove it. Quit just telling us that we have to have this.
Your argument, Tracy Arnold, suggests that all of my listeners' rights, let's say the right of free association, the right to vote. Of course, voting is just a privilege, but let's just call it a right for the moment. The right of voting, the right of free exercise of religion, the right of free speech requires the absolute unfettered mobility of that person to go from point A to point B, to meet people, to get things printed, to go to meetings, to go to worship assemblies, to go to political gatherings, to attend social events, county fairs, to go to the market for farming goods, to have food to eat. You have a right to eat, right? we're told we have a right to kill our babies, and we have a man in our state has a right to marry another man. So the idea of rights are really excessive and extensive, and the state is expanding those rights on and on, it seems, but not here on the movement of the person.
Right, and the Constitution, it allows these states unlimited taxation, but they are limited to taxing property and privilege. And the legislator may deem any business, occupation, or the like a privilege and tax it as a privilege. But first, it has to be a privilege.
And I wonder how it is that the use of the road has been converted into a privilege, Tracy. Tracy Arnold of Adamsville, you are involved in you were cleared of in a driver's license case when the officer didn't show up, and now you're planning on filing a lawsuit alleging oppression under Title 42, the 1983 provision. You're saying that you have an absolute right to travel, and tell my listener how these other rights guaranteed in the Constitution and given to the individual by God, that inhere in him as a human being, that belong to him, that are unalienable. How are they all connected? Can you chop out movement of your person and reserve the other rights? Is it possible to do that, do you suppose?
No, it's not. And so you don't have the right to freely associate with your friends and your family. You don't have the right to the due process clause. I mean, you don't have the right to actually go to the courthouse unless you know somebody who can take you, because you can't leave your house without that badge and incident of slavery. Let's see. Well, heck, you can't have the right to bear arms if, I guess you can at your house, but you can't exercise that right outside of your house, which I guess that's all right.
Yeah, you can't go anywhere freely with your arm.
Right. You cannot leave your house. You can't go to the doctor. You are not free. You don't have the right to life, liberty, and property. You don't.
Well, you mentioned Tracy Arnold that the state has the authority to convert any occupation or calling into a privilege and tax it and regulate it. That would be, for example, lawyering or accounting or doctoring. There are architecturing. Right. There are many chiropractic. There are many callings that the state claims ownership of and then doles out the privilege of entry to those who pay the money, play the game of submission by taking coursework and so on. How is it that using a car is an occupation in itself? It's not. I mean, it is used in occupations, but the use of a car, I wonder, how can that possibly be conceived as a privilege or an occupation itself?
Are you there?
Yeah, I'm here. Did you hear my question?
I believe so. And I think my answer, you were breaking up a bit.
Sorry.
But I think my answer is 94 U.S. 113 says that when the privilege ends, the power of regulation ceases.
What does that mean?
Correctly.
What does that mean?
That means when you're no longer engaged in the privilege of engaging in for-profit activity affecting a public interest, then the power to regulate that for-profit activity ceases. You are no longer required to, like if you're, I would say, well, I was going to say, if you're a doctor, but if you're not practicing as a doctor, then you're not required to have that license.
This is
You're only required to have that license to be a doctor, if you're engaging in medicine or, you're being a doctor.
This is David Toulis, and we're talking with Tracy Arnold. She's fighting for the right of travel. She's a remarkable young woman, 25 years old. She and her husband, Bill, have 6 children, and we'll be right back. I've got some important messages for you to hear. David Toulis, Nooga Radio, 92.7 FM, Nooga Radio, live on Facebook. Go there now.
Chattanooga Morning News with Russ and Val. Weekdays from 6 to 9 a.m. on Nooga Radio, 92.7 FM. 3, 2, 1. Chattanooga Radio. Digital FM 95.3 HD4. 92.7 FM's news now.
In Gordon County, a homeowner fired shots to protect his property. Police say 44-year-old David Tucker was arrested. He was found with a bullet wound. The homeowner says he caught Tucker trying to set his house on fire, so he shot him. Athens firefighters rushed into a burning building to save an elderly man and women who were trapped inside. Firefighters say the neighbors saved the victims as they shouted to them that there were people inside. A female firefighter was hurt when the ceiling collapsed on her, but we're told she'll